at paragraph 3 and 4. Paragraph 3 and paragraph 4 of the affidavit confirm that the accused person, through his agents, EACC and now this has been reported and is captured under annexure number R38. Italy Police Station. R38. PR38. Annexure PR38. We have a list photographs of security vehicles.
With your kind permission, I wish to raise an objection. An objection now is founded on section 106B of the Evidence Act.
That is your name?
Willis of your counsel first accused. Section 106.
Based on
Section 106B
on electronic evidence.
on electronic evidence.
You get it time.
I'm not raising an objection because it's highly required.
You get your time, get it.
We have a next
I want to conclude the directive.
This is a series of photographs. Weapons RR1 to RR37.
1, 2,
RR37. These photographs depict vehicles for the ACC, National Police Service, that were vandalized at the residence of the accused person. Yesterday, when the officers were executing the movement.
execution?
That is, doing research, persons to receive application E716
This legal application number
E716 of medical price. That is able to involve photographs RR3 to RR10, RR3 to RR10. The
Come again.
060. Africa development. When the photographs are ready, the big ACD 62HX. What is the test of interfering with witnesses? It is not beyond reasonable doubt. The test is just a reasonable prospect that is created with the witnesses.
The test is
a reasonable prospect that the accused person will tamper with the witnesses and the evidence.
Perhaps, and I'm aware of the directions you have given about the temporal. Perhaps we need your guidance whether counsel can go outside the content of his affidavit and claim to bring averments that are not contained in the affidavit, because that will prejudice us in terms of our response. Because there is no averment in the affidavit that effect that the proposed witnesses are the subordinates of the government.
I'll give a guidance again. Whatever you pick along the way from both submissions, kindly bundle them together. Once you rise, I expect that you address all the issues in one suit.
I want to
But let me record you first. Mr. Kuna, give me some time. I need to record his objection. everyone have managed to
I will repeat you all that.
How long more? I thought we were going to take 3 minutes. Now we are going, we'll be sitting here the whole day. Just off the car. How long more?
I'll take it seriously. Just summarize it.
10 minutes. Continue, Mr. Cook.
Yes, sir. I will repeat
So
that.
your 10 minutes.
We are submitting that once disclosure is done, the witnesses will be calling officers from the first accused time. Those are disciplined. I'll take the second name. It's a very important offense.
Sorry?
I'll go to the second compelling reason.
Second.
When approval of the child sheet, the amounts will appear caution.
The amounts will appear.
Minimum, 1 million. After the deed, the Honor will win this case. And we draw your attention to section 62(1). of the Act. 62(1) of the Act. In the event we succeed, that provision is very punitive.
In the event,
We succeed,
we is
the
the
DPP
DPP.
prosecutes this case, we get a conviction.
If is successful.
Yes. We will be moving to section 62, subsection 1. And now that the severity of corruption cases. We did the recipe for someone to interfere. We submit in the positive. Lastly, public safety. I've alluded Your Honor to what transpired yesterday. And I've alluded that investigations with regard to other cases are ongoing. Our submissions is that if we release the accused person today, what transpired yesterday will happen. And we are apprehensive that in the interest of justice, in order to protect the integrity of the criminal justice processes, that obligations out, and at least for the court to have an independent opinion, a plea report be available. A plea report be available before this court and decide on this issue. Thank you.
Mr. Sorry, Your Honor. Just to underline that our prayer is that the first accused be denied bail. That probably is the last sentence. Thank you. Mr. Jero, in July, how many of you would like to plead this bill? I'll take 5 because I listed how 11.
Yes, and not all of us, not all of us.
So how many? Just to manage our expectations.
About 5 for practically 5. If you from drama, drama is just going to be because the issues are straightforward, But let me start by introducing Senior Counsel John Greenwan. He's
Good morning.
so we have an interpretation. Then I will do this also here.
So that is
Let me be the first one to draft this.
allow me to record.
Let me at the outset state that the prosecution is causing unnecessary drama in an otherwise straightforward matter. And our focus at this point will be the rights of the accused person who remains innocent unless and until he is proven guilty. So no amount of reasoning. Yes. So no possible grounds can be advanced that can be directed at taking away the accused person's rights. That should be the starting point. And then some Kenyans say, Your Honor, as a counsel was now practiced for 33 years, I get concerned when
How long is that?
33 years.
That is not for intimidation.
When we talk
But I'm sure Dr. Hamino is smiling at you.
Actually, it's a sign.
Very sad.
Your Honor, when prosecutions are forced to teach this court the law, citing authority, citing sections, trying to how to deny it. Before we stand here and pass about, I'm certain that they will bring in what they're saying.
Sorry, Your Honor. I know the court warned us of decorum, but we plead, I am just 12 years in practice, we plead that senior Macharia doesn't get personal. We are just here for our cases. Anything that we do is not personal. So we plead with him to have mercy on us and just stick to his case without attacking us. Thank you.
Mr. Jalango, to record the objection.
There is a special reason, Mr. Njero, I did what I did to your side, so that we remain focused. So remain in that trajectory.
Absolutely. My view is that we have mercy on the accused person. Let's not talk about mercy on the prosecution or media. We are outside, it is him who's left in custody. Now, Your Honor, I'll say this with tremendous respect. What we have here is warfare, which I urge you, Your Honor, to take judicial notice of, because we live in this country, we are interacting with social media, we know what is happening in our country today. And none of us can afford to shut our eyes from that. Independent agencies are being captured and being used to weaponize matters of justice. That's what lawfare is all about. Where you use legal processes to attain an ulterior objective, which is to harass political opponents. It is sad, extremely sad. Your Honor, I'll make a confession to you. I was last in a criminal court defending somebody 20 years ago. But this matter made me extremely agitated, and I said, I will come back to the criminal court to defend someone. Not because of his status, because we can't allow a country to degenerate to a situation where the criminal justice system now will be used to harass opponents. That's wrong. We shouldn't allow it. Your Honor, I am one of the few lawyers who have had the advantage of having been part of independent agencies and also been in private practice. One of the few. And I know how things operate in those agencies. I was the first year of independent police oversight authority, and we had a lot of run-ins in the executive. Constant interference, attempts to direct us on how to do our work, including by the current president when he was elected president. And this is factual. It's in public domain, it is known.
Mr. Njero,
I'll give the context. I'll give the context.
the focus.
Yes, I'll give the context.
Focus here, Mr. Njero, a minute.
I'll give the context.
A minute, Mr. Njero. The focus here is the accused, the law, the constitution. You understand our parameters, if you like. There are some parameters I am unable to swim in. I may not be very able to swim in. But I can swim in the constitution, I can swim in the law, I can swim. That's why I can speak in submissions around those lines.
The reason I'm telling you that, Your Honor, so that I can go straight to the context,
Yes.
is that independent agencies will come here and pretend more often than not that they're doing their work independently. I'm telling you, as someone who has been in those agencies, that unless, as an individual, you have the wherewithal to resist and do your work correctly, very few money to do that. That is the context. I'm not here to talk about where I was.
Sorry, Your Honor.
It's just to indicate.
Sorry, Your Honor, we are forced to object once more on the question. The factual matrix that the very learned senior is giving us are things that, with respect, he cannot tell us from the past. We would believe him, and I know he's a very truthful man, But for us to believe what he's telling you to believe, let him give us an affidavit of those facts so that we're able to respond to those facts. Without that, we humbly plead again. We humbly plead that he gets back to the case and not tell us the other things that are factual and there's no affidavit. We plead with him. We understand that he's previously the commissioner. We understand. But let him get back to our case. Thank you.
To respond to that, look at the affidavit.
A minute, Mr. J. I complete the recording. Mr. J, your brief response, you are responding?
Yes. If you look even at the affidavit, they've made general averments. To start with, problem number one, they serve us in an affidavit this morning. What time did they expect us to respond to that affidavit? You know what is the trick? That it is designed in a manner that will expect us to make an application for a journey so that we can file an affidavit. And in the meantime, the accused person continues languishing in custody. You know those tricks. Then the affidavit itself is marred with general averments. This is factual. They are talking about respondents agents. They are not naming which agents.
So just to be clear, you responding to the objection or you continue with your submission?
I'm responding
That
to something here. He cannot say that I'm making general averments. Yet in his own affidavit, he has made very general averments that are in support of denial of bail. Then he expects that I shouldn't be able to respond to that. At least from the back. In the very least, that should be expected. He can't have a state and Egypt. In fact, we should be given more latitude because the subject of these proceedings is the the rest of us are speaking here, and then we walk away. But this is the subject. That is the person we should focus on.
Give me time to give direction. Someone wish to guide again, we focus on the law governing Mutembei. That is the issue of the table. Continue, Mr. Njero.
Now, Your Honor, the accused person is somebody who has served this country for a long time, not just as a governor. Knowledge of who he is in the public domain, including very sensitive security agencies. And he also understands the law by his own right. He understands his obligations to the public security. besides being a governor, elected governor of a county. What was so difficult was just someone to court, telling me to appear in court and such a thing. Why all the drama? Arresting the man and putting him in custody for this kind of charge. Why? It can only be for the sole purpose of punishing him. It can't be anything else. And it is our desire to continue punishing him that is driving the application for him to be denied bail. You cannot allow yourself in realizing that objective. You can't. I have consistently seen the last line of defense of this country. The only one remaining, Your Honor, is the judiciary. And if judges and judicial officers allow rights of accused persons to be taken away, we have no country. None whatsoever. And let's not think that when you allow that trajectory, that anyone will be safe, including the prosecution itself. No one, I can tell you, Your Honor. We need to learn from history. So regardless of what happens here with these protracted submissions and responses and comments, Your Honor, I beg, do not fall under the trap of saying that you're going to write a ruling another day to the meantime he release in custody. Don't allow this man to remain in custody. He's already been punished enough by being put in custody, even for that one night, when he could have been summoned to appear in court and he never appeared. One of my colleagues here will speak about the facts, then the chaser, but I can tell you, Your Honor, this alleged distraction that is being talked about, the accused was in Nairobi. Whatever is alleged to have happened was in Italy. How do you start connecting him to something that is happening hundreds of miles away when he was in the office of EACC? How? So I'll allow my colleagues to say something, but I'll end by saying this. The reality of our times is that between now and 2027, these are the kind of things you're going to see continuously. Lawfare, use of the criminal justice system to intimidate and harass opponents. Your Honor, I once again plead with you, do not fall into that trap. I'm confident you will not do it.
Thank you. Thank you, Your Honor. Briefly, just give me the last aspect.
You can continue, Mr. Jiru.
Your Honor, just to associate myself with the submissions made by Malani Senior and to draw your attention to the content of the charge sheet from where you will be able to drive the mystery. And the accused person is carried.
Slower. Pause after every sentence. The accused person.
It's not surprising that the accused person is charged before you with another person, Wafula Masungo, who is not before you. This is not by coincidence. It is not that Wafula's whereabouts is not known. It's because, Your Honor, the state was in a hurry to perpetrate this mischief. In normal circumstances, Your Honor, such proceedings would not have commenced. When we sought for explanation, Your Honor, my lord senior indicated that he was seeking summons. It's the same mischief, Your Honor. When we sought for clarification from the prosecution, the position, Your Honor, was that you seek summons. And the nature of the summons was not indicated to you. That is to say, Your Honor, therefore the application for you to deny bail must be read in light of that mischief. That other than pursuing public interests as dictated by Section 4 and 5 of the ODP Act, the ODPP is equally pursuing other ulterior motives that are politically actuated.
And our apologies. Passing to the directions, Your Honor, to direct the focus on the charge sheet. The council has anything. Pass on the directions.
Minute and recording is start.
The direction.
Minute, I'll give you directions.
The director will focus on the charge sheet and the issues related to bail. The colleague is submitting on a fact. Unless he has evidence as to what he wants to speak about, we will ask him. Let me stand on the other side and we will read the evidence. So let me speak on Mutembei. And that's what this person. We just want to give notice to anybody unless they are willing to take the law.
Your response, Mr. Diego.
Your Honor, my response is contained in the affidavit filed by the ODPP. It's not surprising, Your Honor, that the affidavit contains mere speculations. It has no tangible evidence that proves to the contrary of what I earlier submitted. If I was to proceed in response to the substantive application,
Minute. Must give direction in the objection. I remind that once more, I belong to the law on bond and bail, to avoid instances which may persuade me to request the fact having evidence from your end.
I am
Which
agreeing.
will render you in a very awkward position.
I am agreeing.
But
Your Honor, the affidavit contains mere speculations. There is no affirmation in the affidavit.
after every sentence,
And there is no affirmation in the affidavit that is linked to the charge sheet before you. The affirmations in the affidavits have no nexus with the charges before you. These are matters that are happening in other spaces, which none of us, neither the prosecution, nor the defense, nor the court, are privy to. That is to say, Your Honor, that to deny the accused person bail on account of presupposed investigations would be tantamount or will amount to violating his constitutional rights. And most importantly, the right to presumption of innocence and the right to liberty. The argument here that the intended witnesses are subordinates to the governor, the accused person, really is not contained anywhere in the affidavit. And the same does not amount to a compelling reason. And so to say, the argument that vehicles were destroyed by his agents when there is clear lack of evidence linking the so-called agency with the accused person, again is speculative. Has no probative value of whatsoever nature. The same is not empirical, and there is no nexus between that affirmance with the affidavits and the accused person. And as such, that cannot be considered to be a compelling reason. More annoying, Your Honor, more annoying is that the office of the ODPP, which is fully funded with the taxpayers' money, had no courtesy of proving the ownership of these vehicles. You know, the producer of the so-called annexures, for instance, we will not tell you who is the registered owner of KBU 734Y. Again, from the same annexure, you will not tell who is the registered owner of KCH 046T. It will not tell you who is the registered owner of KAE 7-8F. And you're being invited to deny bail on that ground. Registration of motor vehicles is a legal process. It is guided by the Registration of Motor Vehicles Act. And if you are courteous enough, please respectful to the process and the proceedings, and holding the values of the Constitution of accountability and transparency, they would have consulted the NTSA. I went to just as a pen off and invite my other friends to draw your attention to the charge once again that there is no charge that the government is facing that is linked to its office. There is no way in the charge sheet that says that the governor abused his office. There is no way in the charge sheet where there is a charge of conflict of interests. That is therefore to say, in the absence of such kind of overcharge, in the absence of evidence, the argument and the averments by the prosecution is not being believed. I was perplexed, Your Honor, in summary, when I heard my own friend Mr. J.V. invite you to look at Article 50 in isolation of Article 25 in light again of Section 8 of the Magistrates Court Act. He invited you to hold that the only jurisdiction you have in that respect relates only to Section Article 25 A and B. Curiously enough, and in the attempt to persuade you, he believes the presumption of innocence and a fair trial from Article 25. He tells you that the Your Honor, that the presumption of innocence.
I need to stop.
So he tells you that the right to presumption of innocence under Article 50, as protected by Article 25, can be limited under Article 24. That's a fallacy. It's a fallacy, it's a misconception, it's committing injustice and defiling our Constitution. What is compelling? If you look at the Blackstone's dictionary, it will give you as to what is deemed to be compelling. That thing must be a strong issue, it must be convincing, it must be legally justifiable. It must be, or it must have the effect of compromising the integrity of the proceedings. None such averments has been pleaded. No evidence produced. No law quoted. No case law referred to. And as such, Your Honor, the granting of bail to our client will not prejudice, will not compromise the the integrity of the proceedings, will not affect the so-called pending investigations. Be minded of Article 24 and be minded of the test therein. When can a right be limited? A right can only be limited if it is just reasonably justifiable in a democratic and an open society. I invite Mr. Jerry to guide us on who next. Thank you very much.
Now, worried. How long more?
We won't take more than 10 minutes.
10 minutes.
I also give you case law.
So how long are you?
10 minutes.
10 minutes.
Another
Another
six.
This is they'll be very brief. We have 4 more, but they'll be very brief. I'll manage the situation.
Always remember, the court has also business. So if we submit here the whole day, we understand the application, right?
We understand.
So we cannot submit the whole day and expect magic. We should be reasonable, and they say, for a wise man, one sentence is
Absolutely.
you don't need to give 100 sentences in circumstances where you can give 1 sentence. I think that broad guidance serves us right?
Yes.
So we don't need to talk, all of us. In fact, I expected Mr. Njeri to ground this. There is no need of all of us.
We will be very brief.
We are guided.
So this is Mr.
Chesa.
Mr. Chesa, I'll give you 5 minutes.
Very well. Your Honor, I want to start by raising an issue with the manner of arrest. Which manner violated Article 25A of the Constitution and Section 8 of the Magistrates Court Act gives the authority to inquire into these violations. What this court gave the EACC was search warrants, not search warrants. Which they abused by literally breaking into the accused person's residence in Kitale and Nairobi, bundling him into a police vehicle and detaining him at the Integrity Center offices. We hold that the arrest was barbaric, unlawful, and an affront to the dignity of the accused person. Your Honor, to deny bail, the High Court in Danson Mgunya and another. This is the Mombasa criminal case number 26 of 2008. The High Court said the prosecution must provide cogent, the term is cogent evidence and not mere allegations. To have been told through the affidavit of Mr. Rono, he keeps referring to some ghost creatures called agents of the respondent. Agents of the respondent attacked ESCC vehicles. Agents of the respondent shouted at Integrity Center, and that's a very serious threat. They have not drawn the matrix to link Governor Natembeya to the so-called agents. Was it Governor Natembeya's wife? Were they governor's children? Were they his staff? There is no such evidence placed before you. And those who amount to rumors, and this court must not listen to them. The accused person, Your Honor, is a decorated career civil servant. He is the governor, government of Trans Nzoia County. He is a deputy party leader of one of the most progressive parties. In all this, he is not a lonely man. At the time, the so-called ghost agents were shouting at the Integrity Center buildings. The governor had been locked up in the police cells. He had no access to his phones. He was only allowed one advocate, Mr. Simiyu. The rest of us were locked out. Jero was asked to get clearance for made escape. Jero was asked for clearance for made escape to access his client. At what stage the governor plan with the so-called agents to do the unimaginable things that the state is supporting? In Nairobi miscellaneous criminal application number 351 of 2016, in Nairobi miscellaneous application number 351 of 2016, the court said that the seriousness of the offense per se is not a ground to deny bail. At the time of arrest, 2 more minutes, Your Honor.
I just
2 more minutes, will be done. If this court allows. But just have 2 case laws, and could I do that 1 case law?
if we can stick to the directions of the courts.
I understand you.
You've already done more than 10 minutes. I gave you 5.
Yes,
I
one more.
closed my eye to say you're finishing on the 6th minute.
Okay, yes, 1 more. In that case, you recorded that the seriousness of the offense.
I repeat, 1 word is enough.
Lastly,
I don't know why we get this temptation, that the more I speak, is the more I persuade. Sometimes it's counterproductive. Can I bring it to your attention?
yes.
Sometimes it is counterproductive.
This last one, R versus Richard David Alden. R versus Richard David Alden.
Richard.
David Alden. The High Court at Nairobi. Criminal case number 48 of 2016.
Second case. Just list them. I will look at that.
Very well. I think that was the last case, and that the person must demonstrate actual witness interference, not mere allegations.
Straight.
Witness interference. Employees of the county government are retained by county service board, and not the governor. Therefore, there is no relationship between the governor and the employees of the county government, save for CECs who are merely policy makers. That is all.
Your Honor, with your permission, Mr. Simi was the accused person in the ACC. He only say 1 word. He follow your guidance. Your Honor. Mr. Simi. Your Honor, take 2 minutes. And I'm addressing
Proceed, Mr.
Thank you, Your Honor. Your Honor, number 1, I just want to write on what Mr. Echesa has said. The accused person did not have capacity to
accused
direct.
person
Did not have capacity to direct third parties to commit acts of vandalism. Your Honor, I have an inventory.
Slower. You need your 2 minutes. Let's take it slow.
Your Honor, I'm worried about my 2 minutes. Your Honor, I do have an inventory. Yes, Your Honor, which will demonstrate to you that indeed, as at 6:30 a.m. yesterday, the accused person had lost his 2 phones. And of course, he was in custody. So he could not speak to third parties. So, Your Honor, the averments in the affidavits by Mr. Robert Rono is certainly not accurate. Number 2, Your Honor, the place where they went to conduct searches. Your Honor, I want to refer you to the affidavit of Mr. Rono at paragraph 3, where Mr. Rono said that among other places, they went to accuse persons Kitale Milimani residents. That is repeated
are paragraph 4 and paragraph 5 and paragraph 6 of the affidavit. Now, Your Honor, juxtapose that to the order. The order that they received to search the accused's premises had the following residences. One is Rongai residence in Nairobi. 2 is a residence in a place called Kibomet.
Come again?
First is
No, the second.
second is a place called Kibomet. Kibomet. Third is Nairobi residence in Kileleshwa. Okay. So that, Your Honor, when you turn to the affidavit, and of course they are using paragraph 6 particularly to seek to deny the accused person bail, they are saying that the motor vehicles that are said to have been vandalized were vandalized when they were searching his Italian residence. Your Honor, looking at the order, which Your Honor you can have a look at, the Italian residence is not captured. It's not there. And therefore, Your Honor, we are appealing to that the evidence that has been annexed to the affidavit is illegally obtained. And we are not very sure that the pictures that are said to be connected to the accused person's owner are genuine. And Your Honor, to cover that, I would want to refer you to the Evidence Act, Section 106, capital B.
I refer you to SOPEC. Are you ready to listen?
Are you?
Honest to records.
Thank you.
No, I'll try 3 minutes at max, and you stop your time.
Be sure it is 3 minutes.
Stop then. The first point, Your Honor, is just to raise a point.
Now, I expect you start with what you wanted to raise.
Yes, that's what I'm addressing. Your Section 106 Appendix B of the Evidence Act is very clear in the manner in which electronic evidence is used. There is no certificate of electronic evidence annexing those pictorials. By dint of that section alone, there is no evidence in support of the bare allegations in the affidavit. There is no basis to even advance now any compelling.
Slow. Let me remind you. There are allegations contained in the
And in the absence of the electronic certificate, the annexures are inadmissible, and the court should expand them. In their absence, there is no evidence brought to court to support the opposition to bail. Finally, Your Honor, you are told that this court cannot interpret the Constitution. Section 3 of the Judicature Act lists the sources of law in Kenya that this court is called upon to apply. This court can apply the Constitution, including the Bill of Rights. When we say the court to apply Article 49, to apply Article 50, We are asking the court to apply it in the ordinary course of the court's duty. We are not asking for interpretation. Last point. Everything remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. The subject of the proceedings is now a warden of the courts, not a warden of the state. Bail and bond or pre-hearing detention should never be used as a basis to punish an accused person who is still presumed to be innocent. And I urge your Honor to so consider this accused person as its warden that will attend to court as and when this court requires it. Thank you.
Mr. Jerry, your last soldier. Is it your last or?
This one, and then we are talking about Amino.
Dr. Amino.
Thank you, Honor. I'll take only 2 minutes.
Professor, you said you were taking 2 minutes.
2.5 minutes. I'm here before you to demonstrate that what I did recently in my second PhD in criminal justice should be put in a maiden opening, and you are the first that I'm hearing before, so I'm very privileged. Secondly, I'd like also to thank my former teacher, Sunil. I think he taught me very well, and that's why I've been proceeding all. Now, the point that I want to make is just 1 or 2. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ESCC and their mandate. I would like to apply what we call strict scrutiny. Strict scrutiny test. Law, whereby the government raises its own legitimate expectation to validate it is incompetency. Incompetency is aligned to rights protected by the Constitution.
Come again?
Incompetency is aligned to rights which are fundamental and protected by the Constitution. If that was the case, then that law must be narrowly, and I mean narrowly tailored to serve a compelling interest. What is a compelling interest? I'm not going into that issue because my senior counsels before me have already spoken about that. How do we look into the classification of what the state has alleged? Classification, looking at the time of the search, the time of arrest, the time taken to drive, the accused, the miles involved in that journey, the manner in which the accused was transported, where the accused slept, presumably in this case a common floor, and how the accused was arraigned in court. Lastly, Your Honor, I may not understand, and please let the court make me understand, whether the arresting officer is the investigating officer and the judge, and is an evidence provider, provision of evidence through affidavit, which even if mandated by statute, and even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances in court, then there is high potency of illiteracy in the judicial, in the government executive system. I rest my case. Thank you.
Professor, you sure you want that to go to record?
I think it should, because I can substantiate.
Literacy in respect to...
Your Honor, what I mean by literacy is not literally academic, schooling, but experience. And if we are to do what we call discoveries in law, the kind of affidavit you have seen here raises issues that can only be raised on discovery.
But you're admitted yourself.
Thank you.
Thank you. Daktari, how long? I'm not even sure whether I will fix time for you.
I will be extremely brief, except I'm asking for one indulgence.
Yes.
I have my own friend in Ethiopia. I always appear with him in the cases. He has got only one word he wants to tell you. That's only one word.
Very well.
One word will take maybe 1 minute or less.
Very well. Continue.
First, please look at the charge sheet. Point 1, the persons named there are 2. The particulars refer to 1. It is impossible to tell which one will be, except for the use of the word government. So we don't know whether the fuller is for government or the volume is for government. The second point related to that is particulars in the charge sheet under the law. And I take definitely something that the court knows how to do that, right, and understand. Those particulars which are suggesting that he has committed an offense of corruption, of conflict of interest. The particulars of conflict of interest are not been indicated. So without the indication, that what you call the seriousness of compelling evidence is not there. If you look, sorry, we have that code, that was this. If you look at count 2, the same problem of lack of particulars. So that there is no evidence that demonstrates the nexus between Mr. Natembeya and the brother. And the third count relates to the manual we don't talk about. Last, and this is about the allegation of banning cars on the boundary. Something I was told when I was being taught to the young parents when I was much younger. We were told monkey see, monkey do. When the government itself gets court orders, citizens have no reason to monkey see, monkey do. When government routinely violates court orders, it is impossible for citizens to trust it. So nobody will trust that they are doing anything helpful. So the citizens are taking after the action of the government. And very lastly, I do recall off the top of my head, the governor of Istanbul, who was charged with the blood of support. The court ordered that we should not go to the county government. So this issue of interference with the subordinates, if there are any, but my colleague, I just every does not say the court has authority and discretion to give conditions that will ensure siblings or this court currently being paid.
Thank you very much. Your Honor, I was very the first point I would like to make to you, respectfully, Your Honor, is that several counsels or advocates have spoken. They have made submission. I would respectfully argue that before you write a ruling, identical ruling, it is very necessary to guide this nation. You release the governor and you tell the audience that a written ruling will be delivered. Your Honor, this has always been done by the Court of Appeal, by the High Court. This has always been done by the Court of Appeal.
This one?
Giving written letter.
Yes.
Has always been done by the Court of Appeal, the High Court, and recently even by the Supreme Court. So I ask you very respectfully that before you rise this morning, you make an order that the governor is released forcefully and you deliver the ruling letter. I also argue very, very respectfully, Your Honor, that to give him a free point, the governor will go nowhere. We all know it. He lives in this country. He has rendered sterling services to the nation. And there's no way he can leave Kenya for another country. Give him a free point. And you will also be educating certain people and certain people that the criminal law of the country must not be abused.
Slower, Dr. Slower.
Your Honor, I'm saying to you respectfully that you make an order before you rise.
Sorry, that I scored and it's not there.
That the governor is released on a free bond and you will give your reasons smart letter. Your Honor, permit me to continue.
Continue.
Your Honor, I'm a child born in the colonial days.
You're a child?
Born in the colonial days.
Colonial days.
I'm a child who received education in colonial institutions. I'm a child who read colonial literature of sociology, anthropology, philosophy, when you had terms like the African mind, how the African thinks and so on, from the colonial. There's one thing I can make you very clear. The criminal law of Kenya has always been abused. It has always been abused by those in power. It was abused during the colonial days. It was abused during the Kenyatta state. It was abused considerably during Moi state. The only president that can put in a word in his favor is Moi. The criminal law was not abused during the
I think the statement is home, Dr. The statement is home.
Oh, thank you very much, Your Honor. Now, Your Honor, permit me to go a little bit further. It is now being abused by the executive, by agents of the state. They have now taken over the criminal law of the country. They are abusing it. The rule of law which we thought was improving is now in ICU. And Your Honor, I'm urging you very respectfully that you can only get out of this quagmire with boldness from the judiciary. Our judges have to be bold. Our magistrates have to be bold and state very clearly that the country will not be governed the way it is being governed at the moment. Your Honor, we live in this country. Every day I'm reading the Senate, I'm reading the Nation, I'm reading the Star, and I go even further to read any other newspapers outside this country. Clearly, Your Honor, what is emerging at the moment, that unless we arrest the situation, nobody will have politics in the country. The country could easily be classified as a banana republic. I filed a case recently, Your Honor, in court, the usual process, that we should refer certain matters now to the ICC.
Your Honor?
That we should refer certain matters of disappearances to the ICC. Let the International Criminal Court come in and see what it can do, that it can come.
If we can deal with Mr. Natembeya first.
Yes. Your Honor, what is the judge? Can someone give me the judge? Your Honor, the judge you are given here, one can even pass in class. The first comes. The governor is supposed to have corruptly received the sum of shillings 1,127,900,000 shillings. You're not saying total that they took away billions of shillings. 1,127,900,000 shillings. Anybody with a critical mind like of John Hamilton can see that this is dishonest. It's nonsense. That you're bringing a governor of the state to the country because of that amount of money. That's on the first page. On the second page, 2,124,668. Hey, what is that? I'm governor. 2,124,668. Sadly, Your Honor, the amount involved is 2,680,461. This is of a manual of Musumo. Your Honor, the criminal law is being abused. During the days of we will make one point clear. A constitution to be meaningful, it must develop something called competency. A constitution to be meaningful, it must develop in some cases something called convention. You would expect that a charge against a governor of the country, the director of public prosecution, would lead the entire file to satisfy himself that indeed a case has been made out before placing such a case before a criminal court. Your Honor, when did the DPPs read the file to satisfy himself that a case has been made out against the president? Having regard to what was being told, yesterday morning, when did the DPP read the entire file? And this is what I may say in favor of Charles and Johnson. He would read the entire file to satisfy himself that indeed a case has been made out against the government. A governor is no small man. A governor is not a messenger. A governor is a person who is ruling and governing millions of people. It is therefore not surprising that the people in his own area were mad to hear that their governor is being arrested. He's being brought into the country, being taken by the police. It's quite clear the file was not read at all. Your Honor, may I draw your attention to the fact that I shall if I'm given the opportunity, I shall be conversing in some other quarters that the courts have no jurisdiction to contain the count they have to that people. That's not jurisdiction of court. And I would strongly refer you to Article 181 and Article 182 in the Constitution. If you read Articles 181 and 182, Your Honor, there is no provision that provides that a charge can be prepared against the governor. The way to deal with the governor is to use the impeachment proceedings that have been provided for in the Constitution. A governor cannot be arrested and charged the way things have been done. The director of prosecution himself, Your Honor, the DPP has no jurisdiction to make or to prepare charges against the government. So there is lack of jurisdiction. I'm making this point to strengthen my submission, Your Honor, that there is no case against the government. Listen, Jonah, one final question, one final submission on the next video. Please don't misunderstand me at all. I've often thought that in a country like Kenya, strictly speaking, you do not have to be right. You do not have to be right in the law at all. What is required of a lawyer? What is required of a magistrate or a judicial officer is to be strong and to be courageous. The mighty new players that rise to the occasion and show those who are in power, who are in executive, that your powers can be challenged, that your powers can be reduced by the courts. And it is the courts that are in control of the country and nobody else at all. If we lose the control of the courts of the country, if we lose the power that the courts have, Kenya can easily and very shortly be classified as a banana republic. No wonder that the president of Tanzania said the word that he said about our country. The country has gone up. And we need young people like yourself, Your Honor, who have got power, to see what we can bring out and maintain the concept of rule of law in the country, independent of judiciary, and to make sure that we can use the word and they borrow the word of our president, that let the executive keep its own day, not to get into other days. And currently, it is not doing so. Thank you, Your Honor. Ask me to honor. Yeah. Your program may say that when the Mahatma, I handled in some other quarters and so on.
Mahatma.
Yes, there is a book here I was referring to impeachment in the Nigerian presidential system. That's where we have a lot of impeachments of governors and so on. And I will be borrowing words from this book. I'm just putting my learned friends from the prosecution notice that they order for this book.
What is the title?
Order for
Your Honor, I'm taking the title. It's impeachment in the Nigerian constitution. I assure the very learned senior that you have come.
I don't have impeachment of a governor, Your Honor. And in Nigeria, you will see when members of the executive swearing that they would rather die than have such a governor in power. Yes, some people, I'm sure, are swearing that they would rather die than see Governor Natembeya in power.
Very well. Mr. Jero, I think we are done.
Yes, we are done with
Yes.
Our father, with the father, the profession, in a city talk. The governor, freehold. But they really want some affordable cash flow. Let him not stay here an hour longer, so that we don't play in the hands of these tormentors. Let there be no conditions. This man has been elected by his people. He has committed no wrong until the case is proven, if at all. There was not even any affection in that effect. So let's not talk about conditions. In fact, that date, one of these expanders, let him get his freehold or cash bill, let him leave. Even a street boy here will not be studying Natembeya. There's nowhere where he will go. We believe. Your Honor, you do the right thing. We have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law. You understand the law. And even as we are doing all these things, you've appreciated it. I have no doubt that today the judgment will work out. No conditions have been sought and shouldn't be behind. Let man go and serve. He'll have his day in court.
Thank you very much.
Sorry, Your Honor, do we have a right to respond?
Of course, there are any objections. Mr. Owiti, together with who?
I'll just go alone. Most
I not specified.
Yes. Your Honor, start with the jurisdictional issue that has been raised by counsel, especially the very learned Dr. Amino, as to whether or not this court properly has jurisdiction to entertain these charges. And whether or not the Director of Public Prosecutions had power to institute these charges.
Yes.
And that is related to reference to Articles 181 and 182 of the Constitution relating to vacancy in the office of a county governor in Kenya. I believe, I haven't made reference, but I believe that's the position. In brief responses, this court's jurisdiction to entertain anti-corruption matters is provided for under Section 4 of the Anti-Corruption and Economic Crimes Act. So that's a simple answer. Section 4 of the ASEC. ASEC is a law. Point of law is ASEC. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings against anyone before any court other than a court martial, Article 157, 6A of the Constitution. Allow me to make two corrections. My very good friend, Mr. Degwa, tells the court that there is no nexus between the affidavit and the charges, and if your record confirms what I also heard, that there is no such charge as conflict of interest, which is count number 1. I don't know whether counsel read the charge sheet. Count number 1 is conflict of interest. And not just that, count number 2. How could he have gotten that wrong? Conflict of interest. And it does not only mislead you on that. He says that the prosecution, on behalf of the prosecution, no law has been pleaded, no evidence has been produced, no case law has been referred to. I refer to Tom Chomley, It's case law in Kenya. I quoted Article 49(1)H. I quoted Section 123A. These are laws in Kenya. The second correction, Your Honor, my learned senior, Mr. Masharia, if I don't get that wrong, tells the court that the areas, the subject of the warrants issued on 18th of June were limited to 3. Kibomet and another one, it's on the record, Your Honor.
Sharia also.
Oh, Mr. Sibiu, I apologize, that's why I was not sure who's it. Your Honor, for those who have not given me a copy of that warrant, it says, and any other part. Let me just read that so that I get it correct, so that I don't mislead the court. The warrants have been referred to, just below the areas listed. There is an any other office, business, and residential premises wherever they may be situated within the republic, unless we are reading different ones. So that even the search in Trans Nzoia was by law, was sanctioned by law. And then there's the related question as to whether the warrants issued could also be the basis of an arrest. That is the question asked by my learned friend and teacher, Mr. Echesa. Your Honor, this is a cognizable offense. Mr. Smith taught me this way back in 2011. For cognizable offenses, you don't need a warrant. So the arrest was proper by law. So the arrest was proper. The searches were proper. The defense has attempted to repudiate the charge sheet. Although they have gone around the corners, they're not coming strongly about it. But they seem to be questioning the propriety of the charge sheet, or rather the charges. There was no attempt to invite this court under Section 895 of the Criminal Procedure Code to reject the charges. Plea was taken. As it is, the charges are proper, including the particulars. And in compliance against with Section 214 of the CPC. But there is a smaller issue about the amounts. This is related to the charge as well. That a whole governor should not have been brought before you for amounts about 1 million or 2 million. You know, I agree with Mr. Ochieno that this court may not interpret but can apply. In the application of the constitutional provisions, Article 27, Sub-Article 4 obligates this court to ensure and promote an equal application of the law to everyone. Equal application of the law. Article 27, Sub-Article 4 of the Constitution. Before this court, you know, I've never had the privilege of appearing before you. And I'm sure my colleagues who have here have brought people with cases of soliciting a bribe. Some of them up to 3,000 or 5,000. They are Kenyans as well. So that the amount, the basis of the charge cannot be the basis to question whether or not the charges are proper or whether or not compelling reasons exist. I can confirm to this court that's a factual issue, but I can confirm to the court that the DPP, in fact, ascertained and satisfied himself that there were charges properly on the basis of which he could institute these proceedings before you. Now, in respect of Article 181 and 182 of the Constitution, we are not attempting to impeach the governor. The DPP has no such powers, legally or factually. But more importantly, whether or not denial of bail would amount to removal of a governor has been answered by the Supreme Court of the land in the case of Ferdinand Waititu versus Republic.
You know, he's raising new facts that were not part of address to the court.
That's a question of law, Senior.
No, it never came up, Your Honor. We perhaps need a very clear ruling on that particular objection, because we never had those submissions.
When Dr. Aminu raised Article 181 and 182 and said that removal can only be by other parties, not the DPP or this court. That's what I'm answering. And again, because Mr. Ndegwa did not even know that conflict of interest was count one, he may have missed this as well. I withdraw.
If you have withdrawn, I wanted to clarify, but I scored me Dr. Minute saying something else.
Yes. He's trying to mislead. Unfortunately, he's trying to mislead the court.
Now that he has withdrawn, there is no need to clarify that point.
So, Your Honor, I further
scored him differently.
Yes.
So, now that you withdraw that point, I will not.
Most of like I've also withdrawn the arguments on 181 to I scored it differently. Back to the question of bond as I conclude. Page 19 of the Judiciary Bail and Bond Guidelines, at the very bottom in the footnotes, refers to a case of, Republic versus John Kahindi and two others, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines. The import of that case, Your Honor, is that the prosecution does not need to avail an affidavit in opposition of bail. Anyone can confirm because the guidelines are available online.
The prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that you make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there is no basis. If we can come without an affidavit, there is still basis. There's also the argument as regards saying that we are not proved. Sorry, Your Honor.
We are now on your 12 minutes.
2 minutes and I'm done, Your Honor. I underestimated my abilities. I'm sorry.
You can't admit that. No, your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
Yes, yes.
A minute. Continue, Mr.
Thank you. Your Honor, I was referring to, please just help me direct. What did I say last? Kindly.
Last you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate under
that was concluded.
Then I can move to the next point. Your Honor, the other issue as regards bail, as I conclude, is that there is an admission from the defense, at least evidenced by Mr. Echesa and Dr. Haminwa. In Mr. Echesa's words, the first accused is a governor of a county. He is a deputy party leader, and he is not a lonely man. Verbatim, if I got it right. In the words of Dr. Haminwa,
I don't know whether Your Honor you misquoted in my presence, especially in terms of understanding. I don't know points of law.
You were not sure what you are objecting on. Is it points of law or what you say?
As in, you have quoted my statement in my presence.
Yes.
You clearly misunderstood it, and you want to go to the next person without clarifying the question.
Sorry, Your Honor, I have not interpreted what Mr. Echesa said. I have quoted it as I captured it. So the court can confirm that he said that the first accused is the governor of a county, is a deputy party leader, and is not a lonely man. I am quoting you verbatim. I may be wrong in my interpretation, but in hearing you, I can't be wrong.
Points of facts, points of law.
Your Honor, I'm coming to the point of law. I'm still quoting you. You cannot be the point of law. I am coming to the point of law. Yes, I'm still quoting so that I come to the point of law. Dr. Haminwa, on the other hand, says that the people in the first accused area were mad yesterday as a result of his arrest. Those are two admissions as to and thirdly, I am reminded that my very good friend, senior Dr. Harunubi, mentioned that monkey see, monkey do, that the people have seen and are doing. The point of law we are making is that there is a likelihood of interference with witnesses. And that the influence of the first accused is admitted by his counsel on his behalf, and that it is not far-fetched that he would interfere with witnesses and investigations. Your Honor, clause 4.9 sub-clause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. Yes, Your Honor.
You have said you need 30 minutes.
I am done. That is my last point. 4.9 sub-clause E of the Judiciary Bail and Bond Policy Guidelines talks about likelihood. It doesn't say certainty as proposed by Mr. Nego. If there is a likelihood because of that influence, there is a compelling reason you must deny bail. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouth. And we urge you that we have established compelling reasons to deny the first accused bail. Thank you, Mr. Your Honor.
One of the points actually Honorable Jeremiah Kioni, Assessor of Council, who is placing on record.
It's now almost 1. Taking it so far. So I will need a break to do a ruling on the matter. I possibly need almost 1. We take a lunch break. Take a lunch break. Though the issues are going into millions, I will try the best to do it in 1 hour. And Dr. Haminwa encouraged me to deliver decision, give reasons later. Unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by dint of their own procedures. Or for the subordinate courts, that actually can give ground to suspect of my abilities and competence, which I do not wish. So we take a break. We resume at exactly 2 for the ruling. Much obliged.
Welcome back to watching Daybreak on this 20th day of May 2025. In studio I have Geoffrey Wandeto, who is the Member of Parliament for Tetu constituency. I also have Kabala Kile, Deputy Chairperson of PLP Party, People's Liberation Party, right? Great. Senator Veronica Maina, nominated Senator of the ADA Party, the governing party, and also Professor Maxwell Miyawa, International Development Law scholar, and also teaches at the Kenya School of Law. Before we dive into the conversation, there's a subject that I want us to take a look at, which is about the High Court has suspended the vetting of nominees for IBC chairperson and commissioners that was due next Monday. Justice Lawrence Mugambi issued the orders after lawyers representing petitioners Calvin Roy Omondi and Boniface Mwangi warned of the risk that the National Assembly may proceed to vet and approve the nominees in the absence of orders. The orders will remain in place until the 29th of May. Attorney General Dorcas Ruo, who filed a preliminary objection on the case, says the court lacks jurisdiction to hear the matter. IBC nominees face another case filed by civil society outfit Operation Linda Jamii, who argued that the nominations are made without the necessary political consultation. The case is due for further direction on the 11th of June after petitioners serve respondents.